listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello, and welcome to another episode of Driving Law. I am Kyla Lee at Acumen Law, and with me, my co-host, Paul Doroshenko.
Hey, Kyla. Nice to
Hi.
see you.
Yes.
I got to see you at the Supreme Court of Canada earlier this week.
Yeah, I mean, that was going to be our first topic this week, was I was at the Supreme Court of Canada. The little braggy topic, but not actually. It was more along the lines of, was going to be our topic in terms of that being at the Supreme Court of Canada, the case, and the judge's questioning.
What I found interesting, maybe you can go into the case, but I'm going to just say off the top, was that you were representing WiCCD, which is Women in Canadian Criminal Defense, and essentially providing a feminine perspective, female perspective, feminist perspective on the issue of being detained by the police. And it was fascinating to hear it. You told me about it, and I had, some expectation of what was coming, but the way that you phrased it and the way you said it was very precise, very clear, and really revealing. Very helpful for me. And I sat there as I watched it, your submissions, and I thought, what's going to be the response of the bench? And I thought, every woman on the bench is going to be sitting there going, yep, that is the experience. Yeah, been there. And then the men on the bench, I like to think were saying to themselves, oh yeah, shit. Yeah.
I
But
didn't think about that.
I hadn't viewed it from that perspective. But the other thing that I thought they might be thinking, and I should give them maybe some more credit, was we're not going to make the law different for men and women. Of course, that's not actually the issue. It's an issue of fairness. But it was your submissions were powerful and thoughtful, and I saw that LinkedIn comment about someone who was brought to tears by them. It was very impressive, Kyla. So let's talk to people about the case.
Yes. Okay. Well, before, you just shower me with praise, I want to say it was not all me. Anita Shigetti, who is the executive director of WiCCD, worked on the oral submissions with me. And the factum was written by me and also a lawyer, Shweta Tejpal, and a lawyer, Kaylee Glosson, and a lawyer, Megan Delaronde, and also our lovely articled student, Alice. So it was a big, big team effort.
It was wonderful. I think Alice had a major contribution in there. I don't know about the contributions of the others. I just know I saw some of her work as it was going through, and she's brilliant and wonderful, and I can't wait for her to be a lawyer.
Yeah.
And it's unfortunate that the articled students don't get listed as people who are involved in it, because, what opportunities do you have to go to the Supreme Court of Canada? I mean, we're actually looking for opportunities to go to the Supreme Court of Canada. People are thinking to themselves, oh, you're not going to appeal this thing. Well, we don't appeal it if there's no chance. We don't appeal it if it's not something that's likely to get where you want to go. We don't appeal it if there's not an issue that's going to get to the Supreme Court of Canada. If that's the goal for the Supreme Court of Canada, it's only in circumstances where there's, some good reason to be there.
Yeah. I will say, I know a thing or two about what's likely to go to the Supreme Court of Canada.
Well, I know you're
400 plus episodes.
a decade of your
analyze.
If you're new to it, people should know Kyla has a weekly video series on YouTube, cases that should have gone to the Supreme Court of Canada but didn't. And she's been doing that for years, looking at rejected applications for leave to the Supreme Court of Canada.
Yeah. Anyway, the case is about your right to silence and the right to be free from self-incrimination. Specifically, and a lot of people, I think, don't realize this because nobody ever tells you, which is one of the things that was brought up in the hearing, that when you're in an accident, every province, every territory has a motor vehicle act or equivalent that has a provision that says you have to provide certain information to the police about the accident. Usually who was driving, how it happened, who was in the car with you. And if you don't do that, you can be charged under your provincial statute. But also, if you do that, the criminal code says, well, even though it's self-incrimination that you're forced to do, we're going to still allow the police to take this evidence, and we're not going to use it as proof of anything at trial, but the officer could use it as grounds to believe you committed an offense and to demand samples or arrest you.
In circumstances where there's also some evidence that you may have committed an offense.
Yes.
Right. Like but it's statutorily compelled statement in violation of your right to silence, and then using the results of that compelled statement for the purpose of a further investigation and bringing your attention.
I mean, it's essentially the criminal code piggybacking on powers that the provincial statutes have that the criminal law would not tolerate.
Yes.
You couldn't write that into the criminal code. It would be struck down.
So it's a creepy backdoor from my perspective. And this is something I dealt with. We used to call the white and powers issue that I've dealt with for 26 years of practice.
Yeah. So it presents two practical problems. The first practical problem is that people don't understand the sort of limits of this. So people will start talking and they'll go too far and they'll say things that they shouldn't have said, or they'll, follow the law. They'll give the statement they're required to do, and then they'll, create essentially a certainty by which they end up charged because they give enough information to fill in the gaps. Usually who was driving? That's the big question. In fact, one of the interveners in the hearing, he was the first intervener to speak in that wasn't the attorney general of somewhere. And he said, let's just take a step back. Because in practice, this is what happens. And took it back to the real world of what it's actually like for people who are experiencing these arrests rather than the academic aspect of it.
Well, the thing is, you're detained and you make that statement because you're compelled to make that statement. And then even if it's not admissible at that point, you can't make a ruling on admissibility at the roadside. And so then the police charter you and you've already made that statement. From your perspective, you've already made that admission. So you end up basically making that admission again after the fact because people don't understand. The police already know. And so they end up basically shoehorning it in after the fact, despite the fact that you've got a right to silence because you think that your right to silence doesn't apply to things that you've already admitted.
Yeah. Yeah. And my perspective on behalf of WiCCD was that this law and using this disproportionately affects women and also, other marginalized people, but we focused on women in our submissions differently because of the different socialization that we have as women. We're taught to be polite and cooperative and not to argue and not to assert ourselves or assert our rights because we don't want to be difficult or bitchy.
You've never heard of Karen? Because Karen would assert her rights, Kyla.
No.
Was that the response from the government when you made that argument?
No, but I actually was prepared for the, what about the Karen stereotype question? I'm sure they would have asked it differently. And I was prepared to answer that. My answer would have been, yes, but even in those moments, those women provide more information because for them, it's a defense mechanism of anger. And in anger, they're lashing out with information.
Yeah, fair. Again, I completely agree with the socialization aspect, but the thing that the thrust of your argument was that and the different response that you're going to have. But the thing that I found most compelling was the concern about being detained.
Mm-hmm.
And a woman's concerned about being detained. And unfortunately, you cooperate out of fear.
Yeah, you get cover over your body.
Yeah. And so you're essentially trying to protect yourself from further detention, and the mechanism in law permits further detention rather than protecting you from unlawful detention.
Yeah. Now, the one thing that came up in the course of the hearing, it first came up in Ian Savage's submissions. He was one of the two lawyers representing Ms. Cordiner, the appellant.
Good guy.
Yeah. He said, it's not that hard. Like, we're not saying that there's going to be this onerous process for the police. All they really should have to do is tell the person, now I'm moving from these questions you have to answer into questions for a criminal purpose that you do not have to answer. Like, just, that's it. That's it. That's that easy. And then for women.
Well, they should probably say the answers you've given to me are not answers that I can use anymore. You would have to answer them again, and you're entitled to not answer them.
Yeah. But like for women, it gives them the permission they need. It is okay. We're creating a social expectation that you don't answer these questions if you don't want to.
Yes. Yeah. Would make it an option at that point where it doesn't seem like an option otherwise.
Like, it's basically just moving the 10A. And I don't know if I explained this clearly in my submissions. I wanted to say it, but it's basically just moving the point at which you would 10A somebody from the point of detention to the point of gathering the grounds for the detention. Often seconds earlier.
Ultimately, to me, it is just an issue of fairness. Like, it's just a simple issue of fairness. And unfortunately, the charter doesn't say you have to be fair. And that would have been I could have saved myself identifying 22 charter breaches in the hearing I just conducted if I could have just said this is unfair. Or I guess we have to try and figure out what is fair and what's unfair, and that's why we spell it out in the charter as best we can. But sometimes, the first version of the IRP scheme ultimately was just unfair, and the judge just lumped it in as a Section 8 violation, when really the argument was it's unfair. In this circumstance, 10A violation, 10B violation, I think, would be the way that you would characterize it.
Yeah. Now, do we have anything else to say about this? Because I know you have a very busy day, and I know you want to move on to our next topic.
Yeah, we better move on.
Okay. Our next topic is about AI, and you might not think initially that this is actually driving law, but it is. It has a connection. So there's a company based in the US called Clearview AI, and they were also working in British Columbia. They had servers in British Columbia, and what they would do is they would work with law enforcement or anybody else who wanted to pay them, and they had bots that would scrape the internet for people's faces and then connect their faces to their names. And then, because it was using this, very expansive facial recognition technology, it could pretty much find any publicly available photograph of you on the internet and the link to that. And then it was providing that information to the police to identify, people of interest or whatever.
Yeah. It started off in the context, I think, of originally a shopping mall or something that was using it, but this company went further and did more.
Yeah. And I think, they have been, thankfully, banned from doing this in British Columbia. So there was a complaint to the privacy commissioner. Clearview, in response to the complaint, pulled all its servers from BC and said, nah, you can't rule on us because we're no longer there. And the privacy commissioner's like, no, you only have to demonstrate a connection to British Columbia, and you're scanning the faces of people in BC, so fuck off.
Yeah,
fuck off.
it's almost like the admission of guilt by doing it. We're guilty, but you can't get us.
And then, and then they argued that, well, no, because if you put your face on the internet, then you're making that public for any purpose whatsoever. And the privacy commissioner again was like, no, you're making it public for the purpose for which you put it on the internet. Your privacy doesn't cease to exist just because you posted something. It's within the context for which you posted it.
Yes.
Which I like. I like that from the privacy perspective. So what does this have to do with driving law? Well, we have heard about companies that are going to be proposing and attempting to do things like AI-powered distracted driving enforcement with cameras that'll watch inside your vehicle and identify if you're using your phone. And then, we've had Richmond having cameras that have facial recognition technology on them, high definition cameras that can see into vehicles. We are in a precarious position with the speed at which this AI technology is advancing, that we could lose our privacy rights for what we're doing in the vehicle and become, as you often say, policed by robots. And decisions like this kind of put up a big roadblock to that.
Provides some comfort to it that the privacy commissioner has this authority. So the company appealed it, ultimately ended up at BC Court of Appeal. And the BC Court of Appeal said, no, the privacy commissioner's got this authority and is properly exercising the authority. And no problem with the decision as far as we're concerned. So I'm glad to see that the privacy commissioner has been backed up by our court, because it often doesn't feel like our court has shows this level of courage, but the privacy commissioner has this particular power, is empowered, and is expected to exercise this power courageously. And so far, our privacy commissioners and the privacy commission has done so, which is really like comforting to me, a person who is deeply concerned about these infringements on our privacy.
Yeah. Well, it's comforting to me, a person who is chronically online, where my face is plastered pretty much anywhere I can get it, that I'm not just consenting to give that to the world for any purpose. That me posting it on the internet for educating people about the law or promoting a talk or showing off my new shoes is just for that purpose and nothing more. I like that, and that makes me feel comfortable.
Yes.
There's a second, a related, it's 2B privacy driving law related.
Right.
And that has to do with Lapu-Lapu.
Mm. Yeah, this is a fairly significant one. It's less privacy law related, though, I think, or less driving law related. It's privacy law related. And that is, of course, a bunch of people who had access to medical databases in BC lawfully within their job, had access, unlawfully accessed information about the victims of the Lapu-Lapu Day tragedy here in Vancouver, and were caught, investigated, some disciplined, some fired. Surprising that anybody was fired with our shortage of healthcare workers, but probably depending on how bad they needed you, the decision was made to fire some. So much information available to these people who have access to these databases held by the government. We've seen a bunch of police officers who were recently disciplined. I can't remember where it was. I think it was in Saskatchewan, for accessing police computers. We've seen these police officers in Ontario who are charged right now. And part of it is that they were using the police computer system to get information that they were giving to bad guys. And the police may have been bad guys themselves on top of it. Again, privacy breaches, information that's held, what information that's held, how much do we consent to it being out there, and who's got it, freaks the hell out of me.
Well, also, don't forget, Paul, as of right now, none of those Lapu-Lapu people can sue, because you can't sue for injuries arising as a result of a motor vehicle accident. Now, arguably, they might have a claim in assault. That's a completely separate issue. Right now, their best possibility of a lawsuit and almost certain recovery of something in the way of damages is for them to sue under the Privacy Act, because that breach is a breach of the Freedom of Information and Protection of Privacy Act, and that act gives you damages just because. You don't have to show proof of loss or anything.
I wonder how many people have been notified about the privacy breach, the breach to their privacy, though. And if they have, I hope they're consulting with a lawyer. But I don't know that necessarily everybody would have been notified. As we know, these regulatory bodies, the Law Society, for example, will not notify victims. If a lawyer does something, or an applicant to be a lawyer does something that victimizes somebody else, the Law Society doesn't phone them and tell them, oh, by the way, we're going through this file and found out you were a victim. So who knows? Who knows if they know? We got about 2 minutes.
Yes. And that brings us to our ridiculous driver of the week, which is a person in Florida, because I love me a Florida man, who had a crash with a school bus. It's actually pretty upsetting. And I know you picked this one just to make a point about something else that we won't mention, but
car safety. There was a really bad accident in Burnaby that was on CTV. There was a group that was in a Volvo They apparently were all okay. The other vehicle is completely indiscernible and the driver died.
Yeah.
And so car safety has been on my mind. And this was somebody driving a convertible Jaguar, and they drove it right under a bus, and it didn't look like they applied the brakes at all. And you're thinking to yourself, like, how do you survive that without getting your head cut off? They drove it under a school bus. So school bus fairly raised up to start with. Bumpers are very high on a school bus, way too high. In my mind, I've never understood why they don't have them low down, because there's nothing to stop them from being low down. It's not like you're going to get wedged up on the ground or something in a school bus. Make the bumpers the height of a normal car. But in any event, drives under a school bus, wedges it up. The person survived. There was video, like clear video of it, right? So you can see it. I don't know how they got that video, where it came from. It was from the side.
Yeah.
What you can't see is that the driver's side of the bus, of the Jag, appears to have not taken the worst of it. So that's the only reason I suspect the person apparently came out without injury. But you got a wedge-shaped Jaguar sports car, convertible, drives it under a school bus without braking. Ridiculous. Lucky they survived. And sad to see that Jag destroyed.
Yeah, I know. One less Jag that'll never be replaced.
Yeah, especially now that Jaguar is not making cars anymore. So, all right, I have to go. I got 20 seconds.
All right. Well, that's our podcast. If you need to discuss a driving law related issue with us, you can find us online at vancouvercriminallaw.com or give us a call at 604-685-8889 and tune in next week for another exciting episode of Driving Law.